Thank you for attending Changes in Federal Approaches to Cannabis, Process and Impact, part of our 2023 Summer Cannabis Regulatory Deep Dive. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Kat?
Thank you so much. Hello, my name is Kat Packer. I am a practitioner in residence here at The Ohio State University Moritz College of Law Drug Enforcement and Policy Center. And I also serve as the Director of Drug Markets and Legal Regulation at the Drug Policy Alliance. I'd like to welcome folks to today's program titled Changes in Federal Approaches to Cannabis, Process and Impact. Before we get started, I'd like to thank the Drug Enforcement and Policy Center for their ongoing efforts to help shape and enrich public conversations about the intersecting fields of criminal justice and drug policy and enforcement and their historical and modern impact on society. The center, as well as its leadership, including Doug Berman, who served as my former law professor, and it's the center's executive director, are doing amazing and constructive work. As a graduate of the law school, it's been a rewarding experience to be able to continue partnering with the university as a practitioner. For today's conversation, I would like to do a little bit of screen sharing. So I'm going to see if I can try and get technology to work with me today. All right. So speaking of some of the work that the center has been constructive and supporting, I'd like to take a brief moment to talk about a recent publication that was supported both by the center and the Drug Policy Alliance, which I published last month. This publication is titled An Equity Action Plan for Marijuana, the Biden Administration's Opportunity to Advance Equity Through Cannabis Reform. In this paper, I explore President Biden's executive orders on equity, which define equity as the consistent and systematic, fair, just, and impartial treatment of all individuals. And these executive orders direct federal agencies to develop equity action plans, or as the Biden administration describes them, first of their kind roadmaps to address the barriers and discrimination that underserved communities face. Beyond exploring the equity action plans in this paper, I discuss how they're foundational to the administration's goal of advancing equity across all federal policies and programs. And I draw attention to the fact that none of the 90 equity action plans submitted by federal agencies mention marijuana reform, despite the Biden administration acknowledging racial disparities. I appreciate the center supporting me in putting out this publication. I'll make sure that I drop the link to this publication in the chat, in particular because in this publication, I suggest that an equity action plan could help inform the administration's action on marijuana reform. In part, it could help inform DOJ guidance, for example, or it could potentially help inform what we'll be discussing today, which is the administrative review of how cannabis is scheduled. As the Director of Drug Markets and Legal Regulation for the Drug Policy Alliance, and as a reform advocate, it's important to me that the government not only change its approach on marijuana, but that these changes specifically end and address the harms of criminalization and address barriers. And so I'd really like to, again, thank the center for their support and for panelists today for allowing us to have a conversation, a constructive conversation, not only about the process that's at hand in terms of scheduling, but its potential impact. Today, I have assembled a group of leading experts and practitioners, and I'd like to now take a brief moment to ask them to introduce themselves and share how they have become familiar with the marijuana status under federal law. And I'm looking at my screen, so I'll start with Shane.
Hi, I'm really excited to be here. I'm Shane Pennington. I'm a partner at Porter Wright in Washington, D.C. I began my career after clerking for a few federal judges, including on the D.C. circuit, where I got a lot of experience with administrative law and administrative processes in the Supreme Court practice group of a large law firm focusing on administrative law issues and challenging agency action. And through a pro bono case, I got involved with some of the research barriers, challenging some of the research barriers associated with the NIDA monopoly, which we eventually, after 3 lawsuits, succeeded in ending. And at that point decided, you know what, I really like this area of law, and I think there's a lot of important work to do. And so I kind of changed my career path to focus on controlled substances issues and drug policy reform at the federal level.
Thank you, Shane. Fatima?
Hi, I'm Fatima Afia. I am an attorney at Rudick Law Group PLLC. I first came to the industry as a litigator. I was part of a legal team that brought a lawsuit entitled Washington versus Sessions, which then became Washington versus Barr. And that was a federal lawsuit against the DOJ and the DEA that sought a declaration that the Controlled Substances Act, as it applies to cannabis, is unconstitutional on a number of different claims, including that it violated the Fifth Amendment right to due process, to equal protection, 14th Amendment as well, right to travel. And so as part of that legal team, we actually appealed to the United States Supreme Court. But before that, we had appealed to the Second Circuit Court of Appeals. And in that process, it became really clear to us that the descheduling versus rescheduling debate was really crucial in terms of how we were going to proceed, because whenever you bring a lawsuit against a federal or state agency, you do have to what's called exhaust your administrative remedies. And so we had to make a decision on whether or not we were going to actually do that. And my work in that lawsuit really opened my eyes to the entire process of descheduling versus rescheduling before the DEA. And, you know, I can talk a little bit more in depth about that experience as we go through this panel, but that's sort of how I came to the industry. And then I transitioned over more into the commercial transaction side of the space. And so now, you know, my work focuses primarily on public policy, advocacy work, regulatory compliance, licensing and application work, as well as corporate law. And so I'm really excited to be joining all of you guys today. Thank you for having me.
Thank you. John.
Thank you, Kat. Good afternoon, everyone. My name is John Hudak. I'm currently the director of the Office of Cannabis Policy for the state of Maine, where I serve as the state's chief regulator and chief enforcement officer for the medical and adult use cannabis programs. Prior to joining OCP about 6 months ago, I was a senior fellow at the Brookings Institution, where I led the institution's research into cannabis policy and politics.
Thank you so much, John. Rob.
Hello, everyone. Thanks for having me. Thanks, Kat, for moderating this discussion. My name is Rob Mikos. I'm a law professor at Vanderbilt University down in Nashville, Tennessee, which still has, I'm sorry to say, some of the most restrictive cannabis laws in the nation. I've actually been working on this issue at different institutions now for probably more than 15 years, working in kind of broadly defined the cannabis law field. I have a particular interest and expertise in a lot of the power issues that surround this field, the power of different government actors, be they local, state, federal, or international, to shape our cannabis law policy. And that's sort of my hook for this particular panel.
Thank you, Rob. And Patty.
Hi, everyone. Thanks, Kat, for moderating, and thanks to my panelists and to all of you for being here. I think it'll be a really interesting discussion. My name is Patty Zettler. I'm a law professor at The Ohio State University, and I'm a faculty member of the Drug Enforcement and Policy Center here, as well as the Cancer Control Program at Ohio State's James Comprehensive Cancer Center. My research and teaching focus on administrative law, FDA, and public health law. And before academics, I served as an associate chief counsel in the office of the chief counsel at FDA. So I come at this from a public health law and FDA perspective.
Well, thank you all again for joining me for today's panel. Part of the reason why I wanted to assemble this group is because there's so much chatter happening right now about the Biden administration scheduling review. And I've been working over the course of the last several months to better understand the scheduling process, to better understand its impact. And as I've connected with different stakeholders that are impacted or involved in the process, it just seems like there are so many different questions that remain. So I appreciate being able to sit in the seat where I'm asking questions this time. And hopefully through today's conversation, both attendees and members of the public can have a better understanding of what's at stake. So part of what I'd like to be able to discuss in full today are the implications of marijuana status under federal law, the ongoing process that could change marijuana status under federal law, and the implications and difference between rescheduling and descheduling marijuana. Although there are 38 states now that have medical programs or have authorized cannabis for medical use, and I believe 23 states today that have authorized cannabis for adult use, cannabis still remains criminalized at the federal level. And I know that whether we're looking at this from an academic perspective, from the perspective of a regulator, a practitioner, or just a consumer or patient, I understand that the consequences of rescheduling and descheduling are enormous, and all signs indicate that a shift is imminent. In October, President Biden made a statement on marijuana reform where he announced 3 steps that he was taking to quote unquote end the country's failed approach to marijuana. Part of these steps were to announce a pardon of individuals with federal marijuana possession charges for simple possession, urging governors to do the same, and also asking the Secretary of Health and Human Services and the Office of Attorney General to begin reviewing how marijuana is scheduled under federal law. I'm eager to jump into the administrative process itself, but I think it'd be helpful to start with some context and some historical context specifically to get a better understanding of how marijuana ended up as a scheduled substance in the first place. And so I'm going to ask John if you can give us a little bit of history to talk about the criminalization of cannabis at the federal level. How did we get here?
Yeah, thank you, Kat. You know, the Controlled Substances Act really lays out a fairly robust scientific procedure by which the administrative agencies of the federal government consider where substances belong in terms of federal control. And that has been fairly effective for most of the history of the CSA. However, the earliest part of the CSA, that is the congressional aspect, the initial passing of CSA, blended what I would consider science, pseudoscience, and politics to make the determinations about those original designations, the original scheduling decisions. And so when we look at some of the original choices that Congress made with other substances, you can see real scientific value, real scientific information being built into those decisions. And then there are other substances, and cannabis certainly falls into that other substance category. The decision by Congress was driven largely by a decades-long propaganda campaign by the federal government, by non-federal entities, by law enforcement, by advocacy organizations, to scare the hell out of Americans about what this substance was, what it could do to society, what it could do to individuals. And so in a lot of ways, it ended up being an easy decision for Congress to say, this is one of the worst substances in our society. Why? Not because the American Medical Association said that, not because leading researchers into the substance said that, but because political actors conveyed this over and over again, and political actors inside and outside of government, to scare Americans and to scare their elected officials and representatives. And so ultimately, cannabis became the boogeyman of much of the 20th century. And in that sense, it wasn't a surprise that it ended up as a Schedule I substance. And of course, attached to its Schedule I substance status is the criminalization aspect to it. And what we know very explicitly was that President Nixon, who signed the Controlled Substances Act into law, saw cannabis as a politically opportunistic, divisive subject that could impact his political enemies, as he called them. And this was also something that other politicians, not just Richard Nixon, people in Congress, governors, et cetera, saw this as an opportunity to enact a type of political will through criminalization against people who, frankly, didn't intend on voting for some of those people. And so a really nasty stew of politics came together to put cannabis as a Schedule I substance.
Thanks for some of that history, John. Part of the context that I think is helpful for folks to understand here is that since cannabis has been placed on the Controlled Substances Act as a Schedule I substance, we've come to learn that Nixon's former domestic policy chief is known to have said, and I'll quote, "You understand what I'm saying? We couldn't make it illegal to be either against the war or Black, but by getting the public to associate the hippies with marijuana and Blacks with heroin, we could criminalize both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did." Just for historical context, and part of what I also think is interesting as I've been exploring this topic is the fact that it seems as though marijuana's placement as a Schedule I substance was originally supposed to be temporary, and that there was a commission that was established to study this very thing. Is there someone who can talk about that? Fatima, can you talk a little bit about that?
Sure, yeah, so that's absolutely correct. The CSA actually created what's called the Commission on Marijuana and Drug Abuse, which we now know as the Schaefer Commission. And part of the enactment of that commission as part of the CSA was that there were supposed to be 9 members appointed by the President of the United States, 2 members by the Speaker of the House of Representatives, and 2 members appointed by the President of the Senate. And so, of course, President Nixon gets the most members appointed to this commission, including the chair of the commission, who is Raymond Schaefer. And so he does appoint the commission. Under the CSA, the commission has 1 year from receipt of funding for a study on the connection between cannabis use and aggressive behavior, to see the extent of cannabis use in the United States at that time, understanding how many people are actually using, how many people are getting arrested for its use, all those sorts of data together, and also understanding what the efficacy of existing federal drug laws had been with respect to cannabis. And so this study was supposed to be completed within a year from the date that they received funding in order to commission it. And they were supposed to come out with a report. And so they did. In 1972, the Schaefer Commission did come out with a report. And among its findings was, of course, that cannabis was not anywhere near as dangerous as we had been made to believe through reefer madness propaganda. As John alluded to, it did not create violent behavior. And the Schaefer Commission actually recommended that they decriminalize on both the federal and state level simple possession of cannabis. And they also encouraged further medical research on the cannabis plant to understand its real medical efficacies, its real medical applications. And of course, the Nixon administration, in light of its racist and political motivations behind even placing cannabis under Schedule 1, ignored completely all of these findings, and nothing was ever done to change the current classification of cannabis under Schedule 1.
Kat, could I jump in quickly? I loved everything that Fatima said, but I want to just share a quick anecdote. After my book on cannabis first came out, I was sitting at my desk at Brookings and I got a cold call from someone, and as I rarely do, actually answered it. And it was a relative of Ray Schaefer's. And he called and he said, "Hey, I read your book and I really appreciated the way that you treated my family member in this book." And I said, "Oh, that's very kind words." He said, "No, I want to tell you a story." It was his grandson. He said, "My grandfather had a pretty illustrious career. He was governor of Pennsylvania, and he was a good friend of Richard Nixon's." He said, and toward the end of his life, he told family members of his that one of his proudest moments was standing in the Oval Office, being berated by President Nixon about this report and standing his ground and refusing to retract the report. That's the type of political environment that this report existed in. And one of Richard Nixon's good friends had to stand there and just say, "No, Mr. President, we're moving forward with this report."
I appreciate that, John. That I think that all of that context is really helpful for the conversation and where we are at present day. So I'd like to shift for a moment and talk about what are we talking about when we're talking about marijuana being a controlled substance? Because I know that the Farm Bill passed, and it seems like now there's a legal distinction. There's certain parts of cannabis that aren't scheduled. Shane, can you talk a little bit about what exactly is controlled, and how was hemp removed from the Controlled Substances Act?
Sure. So technically, cannabis is not a Schedule 1 substance. The Schedule 1 substance is marijuana with an H or now a J. They actually amended the definition recently to add that J. And when you look at that definition, it's awfully technical. And the reasons for the technicality of the definition derive from U.S. treaty considerations that sort of motivated much of the background and sort of fundamental impetus for passing the CSA in the first place. And so marijuana is defined as certain parts of the cannabis plant. And then there's a statutory exemption. It says, all the parts of the cannabis plant except mature stalks, the fiber of the stalks, the seeds that aren't capable of germination, oil resin derived from those seeds, and all these different, sort of rifle shot exemptions. Then after that, the definition also exempts hemp, and that hemp exemption came from the 2018 Farm Bill, and that basically defined hemp to be cannabis, the cannabis plant, and any part of the cannabis plant, including derivatives and so forth, that is below 0.3% delta-9 tetrahydrocannabinols on a dry weight basis. And so there are certain exemptions, the ones that are in the definition of marijuana in the CSA, that do not have a 0.3% limit. So theoretically, you could have a mature stalk with 100% delta-9 THC, and it would not be marijuana, and it would not be a Schedule 1 substance. But that doesn't occur in nature, at least not yet. No biologist has figured that one out. But then for the rest, that actually is within the definition of marijuana, that's not exempt under the definition. If any of that stuff is below 0.3% delta-9 on a dry weight basis, it's hemp, and therefore not marijuana and not a Schedule 1 substance. And then beyond that, there are certain pharmaceutical compounds that have also achieved FDA approval, which are not are on different schedules other than Schedule 1 or are descheduled altogether. So for example, before the 2018 Farm Bill actually passed, Epidiolex got FDA approval, and DEA initially moved it to Schedule 5 and said, we can't remove it from the schedules entirely because of treaty obligations. So we're going to move it to Schedule 5 and then impose certain specific regulatory requirements if you want to import it, export it, quota requirements, et cetera, that don't normally apply to Schedule 5 substances to make sure we comply with the treaty. Then the 2018 Farm Bill passes, DEA passes an interim final rule and says, oh, Epidiolex is descheduled, our bad. But they don't say our bad, they just deschedule it. And they don't explain the treaty situation, which I find intriguing. But yeah, that's kind of where we stand. It's incredibly complicated. But basically hemp is out, which means anything below 0.3%. And then other stuff is out regardless of if it has 0.3 or more. And there are certain pharmaceuticals that have been approved and therefore aren't in Schedule 1.
So it's just a little complicated.
Yes.
Okay, great. So now that we know that it's just a little complicated, I'd like to get into what the actual implications of the status quo today are. What are the consequences of marijuana being a Schedule 1 controlled substance today? And I'd like to ask Rob for his input.
Yeah, it's a key question on why we're spending so much time on scheduling. It's really because scheduling determines how a substance is going to be regulated under the CSA. So substances that are placed on Schedule 1, they are the most tightly controlled substances. As you move down the schedules to Schedule 2, 3, 4, 5, and so on, they become less tightly controlled progressively. So the fact that marijuana has been placed on Schedule 1 means, as a practical matter, that almost any activity involving marijuana, again, not hemp, but marijuana, is going to be prohibited under federal law. That includes simple possession of marijuana, it includes cultivation, it includes processing, and it includes distribution and sale, of course. All those activities are banned because that's a natural implication of its Schedule 1 status. Really, the only thing you can do with marijuana lawfully under federal law is you can administer it pursuant to a federally approved research trial. That's really the extent of activities that are legal under federal law. Now, to be sure, under federal law, it may be illegal, but the DOJ isn't really enforcing that prohibition right now, just as a voluntary matter. We also, when it comes to medical marijuana, Congress has forbidden the agency from enforcing the federal ban against individuals who are acting in compliance with state medical marijuana programs. But there are also, notwithstanding that DOJ forbearance and the spending riders that Congress has adopted, there are also some ripple effects that stem out from marijuana's Schedule 1 status. Those include things like tax ramifications. So even if you're a fully state law compliant medical marijuana operator, you still pay exorbitant taxes under federal law because of an obscure provision of the federal tax code known as Section 280E. You still struggle to get basic banking services because banks don't want to handle the money of this industry, because even if the operators aren't being prosecuted, all that money is dirty. All of it represents the proceeds of unlawful activity. So there are all these different consequences. We could talk about dozens of other consequences that stem from marijuana's Schedule 1 status. You can see why this is such an important thing, why the scheduling of a substance is so critical in determining how it's going to be regulated, at least under the Controlled Substances Act under federal law.
Thanks, Rob. That's really helpful to understand specifically some of the ramifications of the Controlled Substances Act. But as I understand, there is another body of law at the federal level that controls marijuana and cannabis as well. Patty, can you talk a little bit about those laws?
Sure. I think what Kat is alluding to is the Federal Food, Drug, and Cosmetics Act, which is FDA's enabling statute. And I think if there's one thing you all take away from today about FDA and cannabis, I would say take away that whatever schedule a drug is in or total descheduling does not change FDA's authority at all. So, or in any important ways. So Shane mentioned the 2018 Farm Bill, which descheduled hemp. That bill expressly retained FDA's authority. And, you know, there's a bunch of stuff going on at FDA right now around how is FDA going to regulate CBD. You know, the agency's view is, look, CBD is not as safe as stuff we normally put in food. We need, you know, we don't really want to regulate it as a drug. We need kind of new authority to deal with this product. So, you know, I think it's just important to recognize that wherever things land on the sort of Controlled Substance Act scheduling front, FDA's current statutory authority exists and won't change. I do think it's also important to recognize, and I think we'll talk about this more as we talk about criminal penalties, that although there are criminal penalties under the Federal Food, Drug, and Cosmetic Act for violating that statute, they typically, in general, do not reach mere possession or mere use. So FDA's authorities are focused on distribution of products or their components in interstate commerce. So typically doesn't reach like a person who happens to be possessing, say, an unapproved drug and using it for themselves, reaches the entity that is distributing that product. So I'll stop there, but that's sort of the big picture idea.
Yeah, thanks for that, Patty. I definitely will come back to this later. Important to note the FDA's authority not necessarily changing, but I think folks are eager to know how its position may change if there are changes to the schedule. But talking about the schedule, I'd like to get specifically back into the CSA and talk about the ways in which marijuana status can be changed under the Controlled Substances Act. So let's get into the details of the administrative process. First, I'd like to know, is the administrative process the only way to make this change? And then what are the details of the administrative process? Who's involved? What factors are folks looking at? Who's the ultimate decision maker? And Shane, I'd like to start with you.
Sure. So fair warning, this process is extremely detailed. And so I'm going to hit it at sort of a high level of generality. If people want more detail or it may come up, I'm happy to talk about some of the nuances. But at a high level, there are two ways to change a substance's scheduling status under the current federal law. One is legislation, and sometimes Congress does legislate, for example, the 2018 Farm Bill. Although they didn't technically deschedule, they did change the definition of marijuana, which had the effect of descheduling hemp. So that's one way. The other way is, and they've done it with other substances. They've done it with anabolic steroids. They did a change with GHB. They've done different things. So they can do it that way. The other way is an administrative process. And it's important to understand when, some people aren't familiar with how administrative agencies work at all. And those who are familiar are usually, even lawyers are usually, when they think of an administrative change, they think of notice and comment rulemaking or informal rulemaking under the Administrative Procedure Act. And that's where an agency posts a proposed rule in the Federal Register. Stakeholders and interested persons can comment on the rule. The agency considers those comments, responds to the substantive ones, and issues a final rule, which then has the force and effect of law and is subject to judicial review. That process is part of the administrative scheduling regime under the Controlled Substances Act, but it's just one small part of it. And in fact, the process that the CSA calls for is a very rare one that's, as far as I know, I think it's used in like rate making and maybe a handful of federal statutes these days. And the CSA is one that's really flown under the radar that most people aren't aware. It actually requires formal on the record rulemaking. And this process usually historically has taken an average of 9.2 years to complete. This and the way that it works is the Attorney General, whose authority is delegated to DEA, or HHS, whose authority has been delegated to FDA, or DEA, HHS, or any interested person may petition DEA to change the scheduling status of a substance or to place a substance on the schedules. And when that happens, DEA usually just dismisses them without saying anything, and no one sees it because they either don't accept the petition for filing or they find it completely unmeritorious and they sort of just dismiss it out of hand, and you don't see those. And there are a lot of those, I happen to know because I FOIA'd all of them. But if you get past that first gate at DEA, then what will happen is DEA will gather the necessary evidence, whatever that means, and it's a little bit unclear, but it will also request the scientific and medical evaluation of HHS, which is FDA, and HHS's scheduling recommendation. And that first step in getting that information from HHS is extraordinarily important in the rest of the process, because HHS's scheduling recommendation, basically DEA can't go more strict than that. And historically, it never has. It has never overruled FDA to go stricter than HHS's recommendation, at least under the 811 process. There's a treaty thing that we can get to later, but for purposes of the general process, they usually take HHS's recommendation. HHS also sends the scientific and medical evaluation, and DEA is bound to accept HHS's scientific and medical findings in that evaluation, which is extremely important for things like currently accepted medical use and treatment in the United States. Like, that is a science-heavy, medicine-heavy finding, and HHS's view on that therefore binds DEA through the rest of the process. So once DEA has all this information, it then does its own analysis, and this analysis for both agencies, they must consider 8 factors which are listed in the statute, and they must make 3 findings in order to place a substance in the schedules. And I won't go into all the details about what those considerations are and what those findings are. We can get to that. But once DEA repeats the process, having considered FDA's views, it then proposes a rule in the Federal Register. And at the same time, it says, hey, if anybody wants to comment on this, they have 60 days to do so. Also, if you're an interested party, you may request a hearing. And if folks request a hearing and DEA grants the request, then the hearing is done on the record in front of a DEA administrative law judge. And it has like trial-like procedures with, like, testimony and witnesses and cross-examination. You can put on evidence, you can object to things formally, and the ALJ, like a trial judge, will sit there and look at all of that stuff and make up and down findings on it and issue what are called findings of facts and conclusions of law. Once all of that is together, so we have the notice and comment, which we normally have, plus the ALJ record from any hearings, plus DEA and FDA's analysis, which usually spans somewhere in the range of 50 to 150 pages of, Federal Register print. That all goes to the administrator of DEA, who considers it all and then puts a final rule in the Federal Register, which is then subject to judicial review under 21 USC 877 in a federal appellate court. And then once you're done with that, if everybody's still alive and not asleep, you're done.
Okay, so again, just a little complicated. Shane, I'm curious, where are we at in this process? Where do we imagine that we're at with this process now with the Biden administration? And part of the reason why I ask is I'm curious to know, like, when will the first official decision be made available to the public? When does the public actually find out any information that's happening with the process?
Well, historically, chances are you wouldn't find out anything, usually, because usually DEA does not initiate proceedings. It doesn't think there's substantial evidence, having considered all of that stuff, to warrant a change in a substance's schedule or placing a substance on or removing it. So when there's not that substantial evidence, DEA doesn't initiate proceedings, so you don't get a proposed rule, and there's nothing in the Federal Register, and it's a nothing burger that no one sees, right? Complete black box. Now, in the more sort of political salience or public interest there is in a particular scheduling proceeding, sometimes, like in the 80s, for example, and at certain points in the normal rescheduling Kafkaesque nightmare that took 32 years and spanned the the entire history of the CSA up until 1992, I think. They did kind of open the kimono a little bit and say, FDA would actually put its own analysis out there for public comment. And it would say, here's what we're thinking of recommending. And we would like to have a hearing at FDA before we finalize our recommendation to DEA. So that's happened before. Interestingly, Governor Polis in Colorado and Senator, or who was it? Oh, Blumenauer, and several others have actually asked HHS to please open this process up and let us know where things stand, and let's be transparent and forthright about where this is going, since it's supposed to be expeditious, et cetera. That hasn't happened yet. But as far as I know, no one has formally petitioned either agency for that request. So it's just been informal letters, which is fine. But if you really want to get some action from one of these administrative agencies, in my experience, you need to put your request formally in front of them and really press it. And no one's done that. And so if we are to see anything, it will be when DEA eventually, if they do, puts a proposed rule in the Federal Register. And that will be after we have FDA's recommendation, which of course, it'll almost be a fait accompli at that point, right? Because HHS's recommendation, has so much weight in the process, because it's binding on science and medicine, and because its recommendation is rarely, or I think never, ignored by DEA. So the only question would be, what is DEA going to do with the treaties? And so it's just, people need to understand that by the time we see something, yeah, you can comment and you can raise objections, and that can be a very long and drawn out process. And eventually there will be judicial review. But we've already got a pretty scrambled and cooked omelet by the time you actually see it for the first time in public. And as far as where we are, the scuttlebutt is that, and I mean, I think this came out the other day where Secretary Becerra actually told, I believe it was Marijuana Moment, Kyle Yeager, said, yeah, we want to have our recommendation and our input over to DEA by the end of this year, which if that does in fact happen, then kudos to them, because they have moved on an expeditious basis, because historically that process has taken, I think it's like 2.9 years for HHS to get its input over to DEA on average. And so they're moving at a real fast clip here, if in fact they're able to do that.
Okay, that's helpful, because I've been wondering just when an official decision would be made, and understanding that it seemed as though by the time, if there was a change, it's not like there'd be an opportunity for engagement on the FDA's recommendation. We probably won't even see the FDA recommendation until after a rulemaking process is initiated, if one is actually initiated. Is that correct?
Yeah, and I mean, I've tried to get, and I'll try it right now. I see there are 212 people here. If anybody wants to request a Part 15 hearing from FDA on this, I think it might be too late, but we could really try to open the process up. And I would love to just
request like an advisory committee hearing, which is what FDA did when it recommended upscheduling hydrocodone and combination products to Schedule 2. But so there are all kinds of public meetings that you can request. They don't have to be so onerous as a Part 15 hearing.
what I'm thinking that people, just to Kat's question, right? Like, when are we going to see it? And I mean, there might be other ways to get a public hearing or a public meeting, like a town hall style, whatever. But I just don't know that anyone has asked, and that would be great. If anybody wants to do that, let's do it.
Yeah, I'm interested. So we'll continue these conversations. But Patty, I'm interested in getting your feedback on. We talked about the administrative process. Shane shared a lot of information about that, just a little bit complicated process. But can you talk to me substantively about what factors the FDA is actually looking at when it's doing its analysis? And in relation to those factors, what would it take for, what type of evidence would it take for the FDA to recommend either rescheduling cannabis or descheduling cannabis?
Yeah, I mean, that's a good question. I mean, I guess I am mindful of our time. And as Shane mentioned, there are 8 factors in the statute that FDA considers. cannabis, I guess, is somewhat unusually positioned in that there is more widespread use often than when we're talking about a wholly sort of new substance. So, you know, FDA considers those 8 factors. It makes its recommendation to HHS. FDA is situated within the Department of Health and Human Services. So as Shane mentioned, it's actually HHS's recommendation. So HHS has to kind of okay whatever recommendation is coming from FDA before it officially goes to DEA. I'm not sure I have any, I think this is sort of an unusual political moment with the administration clearly interested in FDA giving a recommendation that would reschedule or do something different with cannabis, or at least I think that's what's going on. I defer to others who maybe are following the administration statements more closely. So, I do think this is an opportunity for a moment for FDA to be a bit more flexible than perhaps it might have been in the past about what kinds of evidence it will consider sufficient. But I mean, I guess I think maybe the most important takeaway is Shane's point about petitioning the agencies to open up the process in some way. And FDA does have a formal citizen petition process where anybody can submit a petition to the agency known as a citizen petition. The agency's response to the citizen petition is a final agency action. So the agency can be sued on that response. The deadline is, the agency is typically pretty slow in responding to those citizen petitions, but that is one way to do something like request. I think an advisory committee meeting might be a really sensible request here, because that's a way for FDA to take its question to outside scientific experts. The Federal Advisory Committee Act also requires that those are all open to the public, and FDA posts all the information publicly that's presented to the advisory committee meeting, and they typically happen faster than a Part 15 meeting. But there are other kinds of public meetings that could be requested. So I'm not sure like the nitty gritty of what FDA is going to consider internally is maybe as important as trying to find avenues for public comment if that's what people are interested in doing.
Yeah, thank you for that, Patty. I do have a specific question around just this terminology that I've seen, accepted medical use. And as I understand, normally this term is associated with products, drugs that have gone through the FDA approval process. I'm curious because whole plant cannabis is not FDA approved. How can we get to a point where the FDA can even consider marijuana to have this accepted medical use based on its kind of historic characterization of what that accepted medical use is, meaning, an FDA approved drug?
Yeah, I will defer, I guess, if others want to weigh in. I'm curious what others think, but I think from the FDA perspective, it's actually a pretty tough position for the agency to be in, because for other substances, for lots of other things, we probably don't want FDA claiming there are currently accepted medical uses. Just because it creates some tension with the public health value of FDA gatekeeping for drugs in general. And I do think it is a difficult statutory interpretation problem, perhaps, for the agency about how it can get to saying there's a currently accepted medical use for cannabis without undermining its really deeply important public health role in ensuring that rigorous scientific evidence of safety and effectiveness is created for all the drugs we all use, and that it can help ensure that products that are distributed and marketed to us are safe and effective.
I'd like to go ahead, John.
Oh, I was just going to say quickly, Patty, I really like what you said there. And I think it creates what is this challenge that exists within administrative law, where I think a layperson could look at that term and say, oh, accepted medical use. Well, there's a lot of doctors who recommend cannabis. They're teaching cannabis pharmacology and cannabis medicine in law schools and in med schools and other allied health programs. So of course that means there's accepted medical use, but the sort of lay version of what that term means and the way in which an agency interprets what that term means oftentimes has dramatic differences, and it's not something specific to the Controlled Substances Act. This happens all across administrative law. And so I think it creates a real frustration within the public when they look at a standard and say, well, that's easy. Of course, there's accepted medical use, whereas that's much more complicated and much more difficult, as Patty said, for FDA in this case.
If I could jump in, and I of course completely agree, and I've litigated the 5-part test that DEA has. So really, DEA said, look, FDA approval is one way. Obviously, if something has a currently if something is approved for interstate marketing, meaning a pharma company can profit off of it in interstate commerce as a drug, then certainly that is sufficient to show that it has a currently accepted medical use in treatment in the United States. DEA then said there were a bunch of lawsuits where DEA was unable, well, courts kept rejecting the argument that that's the only way. And so DEA created first an 8-part and then a 5-part test that basically mimics the FDA standard. It requires things like repeatable chemistry, which are virtually impossible to show with a plant. And no matter how much you might want to try, and frankly, nobody's going to do billions of dollars of, clinical trial research on something that there's already a market for across the country, because the only reason that companies put that kind of money into that kind of research is so that they can get market exclusivity on the back end and reap the pharma level profits that justify them making the investment in the first place. So really, it is a gigantic trap, right? However, FDA has said, and I'll just tell you, it's a 47 Federal Register 28150. If anybody wants to look it up. And if I could, I just want to read this. I think it's extremely important. All right. This is FDA. And remember, FDA's views are binding on scientific and medical matters in the scheduling process. And so this is in the context of a former marijuana scheduling process. Okay. And FDA says, quote, a drug may also theoretically be legally marketed without violating the Federal Food, Drug, and Cosmetic Act if it is manufactured, processed, and used entirely within a single state without any connection at all with interstate commerce. The agency has considered whether there is any basis to conclude that the substances at issue in this document have obtained accepted medical use by virtue of totally intrastate production and use, and has found no basis for a conclusion that these products have obtained acceptance of their medical use by that means. Okay, so now ultimately there, FDA says, look, it's possible you could do it entirely through intrastate production and use, right? It just hasn't happened in 1982. Well, fast forward, and you have 38 states sitting here, doctors across the country, right? Recommending this to patients in treatment in the United States. And as much as everyone is absolutely correct about the administrative law principles that make it difficult for an agency to change positions, they can. And there's another very important concept of American law called ordinary meaning interpretation. And there are people on the Supreme Court who take that very, very seriously. And so there's something to be said for that instinctive common sense notion that cannabis, which is being recommended across the country and millions of patients are using, obviously has a currently accepted medical use and treatment in the United States. And I guess it's unsurprising that if you look hard enough, you can find where FDA actually accepted that closer in time to the enactment of the statute, which makes a compelling case for them to be able to sort of say, yeah, we're not remaking the wheel here. We're just saying what we've always said. The only thing that's changed is that now cannabis, unlike any other substance, has in fact achieved this status.
Thanks, Shane. I'd like to jump now to another topic that seems to potentially be limiting on this conversation around rescheduling or descheduling. As I've been looking at the process and some of its limitations, what's constantly come up is the international treaties and the US's obligations under the international treaties. And so part of what I want to be able to better understand is, do US treaty obligations limit the federal government's ability to deschedule marijuana within the administrative process that's happening right now? And then I'm also curious in folks' response to the DEA opinion in 2016, where they articulated that because of the obligations under the international treaties, marijuana couldn't be placed in a schedule less restrictive than Schedule 1 or Schedule 2. So can folks talk a little bit about the implications of the treaties? And I want to start with Fatima.
Sure. So as you pointed out, under the CSA, 21 U.S. Code 811 D1, I'm going to just read it verbatim. The CSA provides that if control is required by U.S. obligations under international treaties, conventions, or protocols in effect on October 27, 1970, the Attorney General shall issue an order controlling such drug under the schedule he deems most appropriate to carry out such obligations, without regard to the findings that are required under either this section or 812B of this title, which includes all the different schedules and the criteria for those schedules. So yes, essentially, based on the language of the CSA, and this is how the DEA has also interpreted its own authority, we are bound, or the federal government is bound by its own treaty obligations. And so because the United States is a member of the Single Convention on Narcotics, among other treaties, that was established in 1961, we do have to some extent, make sure that any scheduling of cannabis or any other drug is consistent with how those drugs are being scheduled under those treaties. So as you mentioned, in 2016, the DEA I think it was the latest rescheduling petition for cannabis that was ever filed with the DEA. In that decision on that rescheduling petition, they did take the position they couldn't reschedule anything below a Schedule 2 in order to stay consistent with the obligations for the Single Convention on Narcotics. Interestingly, though, in December of 2020, I believe, the UN actually, I believe, reclassified cannabis under the Single Convention on Narcotics. I don't recall exactly which schedule they replaced it to, but I believe they removed it from Schedule 4 under the Single Convention, and they acknowledge that there is medical efficacy and therapeutic uses for cannabis. So theoretically, there's a lot of debate with everyone I talked to as to what schedule under the CSA that would mean we could actually reclassify. But I've been hearing rumblings of either a Schedule 2, as the DEA has previously said, or perhaps maybe now a Schedule 3, since Schedule 3 does acknowledge that there is medical use and less of a psychological physical dependence. So that's sort of how we get there. I am interested in hearing Shane's view on sort of more the nuances of the treaty schedules, because I don't know all the schedules by heart. But my understanding, though, is that the DEA has always taken this position, and it's pretty clear in the CSA that they don't really have much of a choice there.
Before you jump in, Shane, Rob, do you have anything that you'd like to comment on this particular piece?
I think Fatima did a good job of sort of summarizing the obstacle here. And the key is to recognize that, at least as a matter of administrative scheduling power, Congress has pretty much tied the hands of the DEA and HHS and the Attorney General to the mast of international law. So if international law requires the United States to control marijuana in a particular way, the administrative branch has no choice but to heed those obligations. And I think that the most straightforward, back to the ordinary meaning of the international conventions, the way that the International Narcotics Control Board has interpreted them, that would probably require the United States to keep marijuana at least on Schedule 2, to not relax the controls any more than that. But one thing I'll add to this is that this only applies to the executive branch. If Congress wants to, Congress can pass a statute saying we don't care at all about international law. And Congress could create an exemption for marijuana, descheduling it entirely in the same way it did tobacco and alcohol and hemp, or just saying sort of legislatively, we're going to move cannabis or marijuana to Schedule 3, Schedule 4, Schedule 5, or some new schedule. So this is really only a constraint on the president's power. It's not a constraint at all on Congress's.
And to add to that, it's also clearly not a constraint on state powers, because as we've seen, multiple states, more and more every day, are legalizing. The UN has called the United States out on this, saying that by allowing states to continue legalizing in flagrant violation of not only US federal law, but of also the international treaties that we are already actually in violation of our treaty obligations. So there's that.
So, and if I could just jump in real quick. So not only are we in violation of the treaties, we're going to be in violation of the treaties regardless of the outcome of this administrative process. You know, Schedule 1, 2, 3, 4, 5, deschedule, we're going to be in violation because of those state legal markets. The CND has repeatedly said that year after year after year. And beyond that, something many people don't realize is that this is part of a lawsuit that one of the lawsuits that ended the NIDA monopoly. We actually found through a complex FOIA process, the Office of Legal Counsel, which is a very high authority in the executive branch, actually found that from the beginning of DEA's existence in 1973, the United States has been out of compliance with its treaty obligations in 3 ways because of the NIDA monopoly, which blocked scientific research in the United States for 50 years. And so we've never complied with the treaties. We're not complying now, and we're not going to be complying unless we address our deeper relationship to those obligations. And I guess that, you know, another thing that has to be said, I just published a law review article about this with Matt Zorn, where we explain that, you know, because of the federalism implications of, you know, trying to enforce a treaty that would require the federal government to go in and sort of stop these state level programs. And also because of the private non-delegation doctrine, the treaty obligations under 811D are very likely unconstitutional. And so the treaty is not a self-executing document, which means there has to be a federal law that implements it as a matter of domestic law. And if that domestic law, Section 811D of the CSA, is itself unconstitutional, then it's invalid. And so that would be another way for the agency to get around that. And right now I'm working on a petition that is teeing up that so that basically they will know that if they try to apply the treaties to keep cannabis in any particular schedule, that we'll be challenging the constitutionality of 811D.
I think also, like, to strip away the legal and constitutional complexities of this, and we just look at the international politics of it, Uruguay wasn't sanctioned for legalizing cannabis in 2013. I mean,
Canada.
and Canada later. I mean, the UN wagged their finger at Uruguay really, really angrily. But if Uruguay is not going to face sanctions from the international community about legalizing, I can guarantee you the United States will not. And as Fatima said, like, Canada, a peer country economically, also got a really aggressive finger wagging, but nothing's coming of it.
Did Mexico even get a finger wagging?
I don't even think they did. And so the international politics there really don't create any barrier for the United States to essentially do whatever the hell it wants. There might be domestic limitations there. There may be, notwithstanding what Shane said, but internationally, you know, it's not going to be, it's only going to be a little speed bump.
All right. Well, I appreciate all of that context. I feel like I have a much better understanding of the process itself. And I'd like to shift our conversation now and talk about some of the implications of potentially rescheduling or descheduling cannabis. And before we get into this conversation, I'd like to try and frame this conversation with 3 thoughts generally. First and foremost, I recognize that there are many different stakeholders and issues that are impacted by marijuana status under federal law. And I want to make sure I have a better understanding of what changes impact whom and how certain changes may leave certain stakeholders and issues without adequate relief. I've, in my exploration of these issues, identified several areas of law that I think are worth considering when trying to understand the implications of changing marijuana status under federal law. And I've put together a chart that I hope to be able to share with folks and get folks feedback on that walks through that. But beyond my personal consideration of what I think are important issues to consider, I also like us to have a conversation in part about where the Biden administration has said that they stand on marijuana and what particular schedule, deschedule would be necessary to accomplish and effectuate those goals. I'd also like to just note that it seems as though, at least according to cannabis journalist John Schroyer, that there's some chatter that the Biden administration may move to Schedule 3. And so I think at least, while I don't want to be speculative on the call, I think it's at least helpful to use this as a hypothetical. So as we go through these different issues, I'm going to ask the panelists to be able to comment specifically in a hypothetical situation, if we were to be rescheduled to Schedule 3, what those particular implications would mean. Does that all make sense to panelists and work for folks? Excellent. Okay, and folks can still see my screen? Okay, let's see if we can still do this. Okay, so I put some time putting together this chart to try and understand some of the legal implications of marijuana status as a controlled substance. And just so folks know, I will be working with Ohio State University and the Drug Policy Alliance to publish this resource following this conversation, after I have an opportunity to get feedback from our experts today. But I'm hoping to be able to use what I've put together for discussion purposes only. Please don't take this to the bank. This is not legal advice, but I'm hoping this can at least help us frame some of the different conversations. And what I've tried to do here is categorize by legal status, by schedule, or considering whether or not marijuana would be descheduled, or addressed through legislation, what the particular implications could be. So we'll go one by one through these different issues. And I'd like to start by talking about some of the research, but let me back up for a second, because I recognize I did not add a key to this illustration. And so let me just try and articulate what some of these symbols mean. The yellow circles with X's are intended to represent a situation status where that activity is technically legally permissible, but highly regulated. The red circles with the X means that it either is not addressed through that particular status of law, and the green circles with the check represent either law being able to address those particular issues, or those things still being permissible under whatever particular status. So I'd like to start with research, and I want to have a better understanding of how either rescheduling, descheduling, to keep with our example, moving specifically to Schedule 3 would impact marijuana related research. And part of what I want to ask is how the research bill that President Biden signed last year, how that is factoring into how research could be changed if marijuana was rescheduled or descheduled. And I'd like to pass that question to Shane.
Thanks. Yeah, so research is kind of near and dear to my heart. It's part of the reason I got involved in this area of law to begin with. And so before that, the president signed the Marijuana and Cannabidiol Research Expansion Act in, I think it was December 2022, it could have been November, but sometime around there. Before then, the way that it worked was, the Controlled Substances Act made research more or less difficult based on the class or scheduling status of a substance. So Schedule 1 substances had extremely restrictive research requirements imposed on them, like basically made it, not impossible, but very difficult to do any serious scientific study of the cannabis, especially cannabis people are like actually using in the United States. And then for other schedules, it was less strict, so Schedule 2 was a little bit less strict. And then for 3 through 5, it was significantly less strict. The statute that was passed at the end of last year, however, changed that approach and addressed cannabis itself specifically. So it says, for purposes of marijuana research, here are the standards, right? And so instead of saying, as long as cannabis is in Schedule 1, these are the standards that apply, it just says these are the standards that apply to cannabis, period. And the trouble with that, I'm afraid, and I'm the only person who's got this fear, I think, but nevertheless, I'm concerned that because the statute now singles out cannabis for very particular and strict requirements, regardless of its scheduling status, the only way we're going to get serious relaxation of the research requirements is if we get all the way to descheduling. Now, hopefully, if my fear is true, right? I mean, hopefully I'm wrong, okay? But if I'm correct, my hope would be that, okay, well, if they rescheduled, say, to Schedule 3, and the research strictures that applied when cannabis was in Schedule 1 still applied because of this recently enacted amendment, that Congress would step in quickly and relax those requirements. But it would just be very unfortunate. I think most people very reasonably think, oh, well, if we reschedule, that's going to really help scientific research. I mean, that's what I thought until this statute was passed. So that's my fear. If it is like the other schedules, though, Schedule 3, aside from that concern, in general, Schedule 3 has a lot less research restrictions than Schedule 1. And so that would be a major boost for the scientific study of cannabis.
Thank you, Shane. I'd like to move on to, and I'm not necessarily going in order of what's on the screen, but I'd like to shift into talking about one of the things that we raised earlier, which is this concept of accepted medical use. And as I understand, one of the major distinctions, if we even just move out of Schedule 1 to any other schedule or deschedule, part of this acknowledgement would be, and I think, John, you were referring to how the agency views accepted medical use. Patty, I'm interested in understanding what the significance and practical impact of this designation accepted medical use is, and whether or not this impacts how FDA would go about approving a marijuana drug. We'll start there.
Yeah, so I mean, and just to, I guess, add to what Shane said about research, it is research with human subjects is highly regulated, even for for substances that aren't scheduled under the Controlled Substances Act. So there's a regulatory regime in place to ensure that human subjects' welfare is protected and ensure that studies are designed, in a way that's valid scientifically. So we actually get information about safety and effectiveness that would apply in many instances, regardless of whether cannabis is scheduled or not, both under the Federal Food, Drug, and Cosmetics Act and under a separate, something known as the Common Rule, which is a regulation under HHS, not under FDA. But in terms of accepted medical use, it really doesn't have any bearing on FDA approval status. So, I think, as Shane mentioned, typically when FDA has said something has accepted medical use, the product has gone through the FDA approval process. I mean, I think it'll be interesting to see what FDA says during this kind of rescheduling scenario, where perhaps it will find an accepted medical use absent an FDA approval. But the FDA approval process and the statutory requirement for FDA approval remains in place regardless of the schedule that a drug is on, or whether a drug is not on the schedule at all. I will say the one sort of nuance there to FDA's authority that might be important here is sort of returning to the Federal Register notice Shane mentioned, where FDA talked about wholly intrastate production. So FDA's authority by statute is tied to the movement of a product or one of its components in interstate commerce. So a wholly intrastate business where a product, all parts of the product are sourced from within one state, distribution is wholly within one state, et cetera, that might not be something that would require FDA approval simply because FDA does not have statutory authority over wholly intrastate business.
Thanks, Patty. I think one of the things I'm interested in getting a better understanding of, particularly around medical and medical use and FDA drug approval, is trying to reconcile, like, what does this actually mean for patients? If if marijuana is rescheduled, does this automatically address, medical use as authorized by state law? Does it mean that we're talking prescription access? What are we talking about here? And Patty, if you can comment, and I'd also be interested in follow up from Rob.
Yeah, I mean, so I think that's a great question. I know folks in the Q&A had written questions about payment. Would we expect payers to pay if marijuana or cannabis were on a lower schedule and FDA made a determination about accepted medical use? And what about FDA enforcement? So, I mean, I think that the big looming question would be, I've been talking about what FDA's statutory authority is, but we can think, I think, as Rob mentioned at the outset, right? Law is not just what's on the books, it's how it's enforced. And, do we think FDA would have an appetite for enforcing, some of these existing medical uses? And, there, I think it's a bit hard to predict, and it's probably product specific. And, the agency typically makes enforcement decisions on kind of a case by case basis, thinking about, where the public health risks are and what the best use of its resources are. But, I think in terms of patient access, I'm not sure it will have a big impact. I don't know that I would expect insurance companies to start paying just because cannabis is on a lower schedule, absent FDA approval. But, maybe I'm wrong about that.
Thanks, Patty. Rob?
Yeah, I think it's important to keep in mind that even if the federal government were to move marijuana down to Schedule 2 or Schedule 3, that would trigger a new set of regulations, both those under the Food, Drug, and Cosmetic Act, as Patty mentioned, but also under the CSA. There are lots of rules governing how companies are supposed to handle and produce these substances, how individuals are supposed to get access to them, and so on. And usually it is, if it's a Schedule 2 or Schedule 3 substance, usually it is more of a prescription rather than just a doctor's recommendation. So all that's to say that there would still be a gap between current state medical marijuana laws and the regulations that would exist under federal law. But if states could somehow close that gap, if they could find a way to reformulate their regulations so actions that are in compliance with state medical marijuana laws were also in compliance with federal laws pertaining to, say, a Schedule 3 substance, then yeah, I think you would have a big impact. You could have individuals lawfully possessing this substance. You would have insurance companies, as long as there's a scientific backing for it, covering the cost of medical marijuana, which is something they haven't done in the past. You would have employment protections kick in under the Americans with Disabilities Act, for example. But that would require some work. It wouldn't happen automatically because there's still a gap between state medical marijuana laws and federal laws governing these substances. The other thing to keep in mind here is that it would have no impact whatsoever on adult use. So under federal law, really it's a medicalized view of the world. So if you've got a controlled substance, even if it's a controlled substance on Schedule 2, 3, 4, or 5, the only valid use for that is medical. There's no other valid use. So it wouldn't really have any impact at all on adult use laws, but it could potentially down the road have an impact on medical marijuana laws.
Thanks for that, Rob. And I guess part of the clarification even around the impact it could have on medical marijuana laws, I'm imagining, because we're still talking, if we're talking about rescheduling cannabis, we're still talking about the DEA's closed loop system, where folks who were producing or manufacturing, distributing medical cannabis would still have to get a license from the DEA. Correct? Is that correct, Rob?
That's correct. And just to drive the point home, consider that cocaine is a Schedule 2 controlled substance. And yet I bet you wouldn't walk down to your neighborhood Walgreens and say, "Hey, my doctor just wrote me a prescription for cocaine. Can I get my drug here?" That drug, because it's on Schedule 2, it's subject to a litany of controls that go far beyond anything any state has imposed on medical marijuana. So yeah, there would be hoops to jump through. There would be licenses you'd need to get. There would be protocols you'd need to follow, new regulations and so on, that would make it restrictive. But you open that door a crack, and there are some people, I think, at least that would benefit from that. And again, if states kind of change their laws, become more restrictive, more in line with federal regulations, might have more and more people benefit down the road.
Got it. Thank you. I think all of that clarification is really helpful, because I've seen chatter on social media, and it seems like there's at least some belief that rescheduling would just automatically legalize medical uses as it's situated at the federal level, or that the operators who are participating in medical industry across the United States would somehow be brought in. And in reality, it seems like there's a window that could open, and it's whether or not folks could contort to fit through that window. And then on the back end, it's kind of every individual product may need to be approved in order for folks to get, for example, prescription access to that particular product. So seems like this is another one of these areas where it may be just a little bit complicated, but I do appreciate folks being able to give clear responses and clarify, no, this is not going to in any way address, adult use programs or medical use. Rob, I'm sorry, John, I'm specifically interested in your feedback as a current regulator. What do you anticipate any of this descheduling, rescheduling, moving to Schedule 3 to mean for state programs and markets?
Yeah, thanks, Kat. Descheduling would be a game changer for any of the state programs as they exist, particularly the adult use programs as they exist. I'm still not convinced that descheduling would dramatically change the way that the federal government views cannabis as a medicine. I take Rob's point that you could imagine under a rescheduling or even under a descheduling process, rules being written in ways that could treat cannabis in a way that we perhaps are not thinking about it right now. But I would tend to disagree. I think it's hard to imagine a scenario in which FDA writes even slightly permissive rules around medical cannabis that would encourage insurance companies to start reimbursing for it. Just the vast differences that states have in the way in which they regulate medical cannabis. I agree with Rob. You could imagine a federal structure that says, well, if you produce cannabis in this way, then perhaps we'll think of it differently. But in reality, we have that already. We have a scheduling system in which companies can bring cannabis-related products to market. It just goes through a rigorous testing and trial process. And so I think there's a lot of false hope in the cannabis industry and among cannabis patients about what rescheduling would mean. But as a state regulator, rescheduling doesn't change my job at all. I'm running a system that's illegal under federal law. Every licensee in the state of Maine is currently breaking federal law every day with what they do. And rescheduling from 2 to 3 or 4 or 5 doesn't change that at all. And so, and one last note, particularly on what might change in terms of accepted medical use or changes to medical cannabis programs. One of the things that I cannot imagine seeing in the future is a scenario in which FDA produces any type of rule that would okay smoked cannabis flower as an accepted medical product. This is the vast majority of medical cannabis in the United States is used as smoked flower. I would be shocked to see, like I said, FDA signing off on that. Tinctures, edibles, patches, other types of products, perhaps. And we've obviously seen Epidiolex being approved as a pharmaceutical, but not smoked cannabis. And there would be profound resistance within the medical community, both inside and outside of FDA, to accept that as having medical cannabis use in a state program in any part of the country, given the views that exist in the medical community about smoking in general.
Thanks for that, John. Fatima, did you want to add something?
I just wanted to say that I largely agree with everything that has been said, and particularly with what John was just saying. And there's been a lot of discussion among a lot of medical advocates in the space that there should perhaps maybe even be not rescheduling to the current schedules, but actually creating a totally new Schedule 6, which would require legislation, but creating a whole new schedule to really hone down on regulations that actually make sense in practice for this product, which is obviously unique in a number of ways from any of the other pharmaceutical drugs that are currently listed under the CSA. And so there is, a lot of, push for this. Don't know how likely it is to actually get through into legislation, but it is something worthwhile discussing and thinking about, because as John alluded to, smoking perhaps might be something that would be completely under the existing schedules, be completely prohibited by the FDA. But if there's legislation that actually creates a totally new framework for how we regulate medical cannabis differently from the other scheduled drugs, that could be a way to sort of transition ourselves into a federally legal industry.
Yeah, thanks for that, Fatima. I think that there will continue to be conversations about whether or not the CSA is like the appropriate regulatory apparatus to deal with cannabis at all. And then, of course, there's a conversation about how we're kind of delineating medical and adult use and whether or not that's appropriate. As was mentioned previously, the CSA is really only meant to deal with research and medical purposes. And the reality is that while I have colleagues who say like all cannabis is medicinal, and I agree with that, not taking a stock of how states are making these distinctions. And if we are going to make this distinction at the state level, maybe it's time that the CSA is just not the appropriate vehicle to do that. I do want to shift and talk specifically about impacts. We talked about how rescheduling wouldn't necessarily address immediately address patients, definitely wouldn't address adult use consumers or state programs, industry authorized by state programs. I do want to spend a little bit more time talking about the cannabis industry. One of the areas that it seems like there would be kind of clear-cut relief is on the topic of taxation. And so I'd like to have Fatima, if you can share a little bit more about how rescheduling or descheduling, even moving to Schedule 3, would impact the ability for the marijuana industry to make tax deductions.
So currently under 280E of the Internal Revenue Code, businesses cannot take ordinary business deductions like most other industry businesses can if they are engaging in the trafficking of illicit substances, controlled substances in violation of federal law. So any businesses that are currently operating in violation of Schedule 1 of the Controlled Substances Act are unable to avail themselves of the normal and ordinary business deductions that many businesses take, which really does leave a lot of these businesses in a financial hole. We're already in a very volatile, highly regulated, highly expensive industry, and to top it all off, you now don't even get these ordinary business expenses. So I actually am going to leave it to the rest of my esteemed panelists to talk about the implications of other schedules, because I truly don't know how other schedules will impact 280E exposure and liability, but I'm interested in hearing everyone else's thoughts on that.
Yeah, thanks. So in my understanding, it's specifically applicable to Schedule 1 and Schedule 2 substances, but if marijuana was moved to Schedule 3, 4, 5, or descheduled, then cannabis businesses would be able to make that normal business deduction. And I see Shane had put his thumbs up, so I'll take that as law. But I think part of what what I've seen on Twitter and social media, and maybe folks can just clarify. I've seen someone ask the question, well, is it just if it moves to Schedule 3, does it just protect the medical portion of the program? And Shane shaking his head, no, any category of activity, if it's Schedule 3, and it wouldn't even necessarily, and I'll ask a clarifying question, it doesn't even make a distinction about whether or not this is a licensed business at the state level or not. Anyone engaged in cannabis activity, if it were moved to Schedule 3, 4, 5 or lower, would be able to make those normal business deductions.
Yes, and if I could just add one point that I think is almost universally overlooked, and admittedly, it's a minor point, but when you're out in the desert and you're awfully thirsty, a drop of rain is a welcome thing. And so it's worth noting that there's not just 26 USC 280E, there's also 26 USC 7201, which says that the IRS can enforce these tax provisions with criminal penalties. It's a felony punishable by prison time, fines up to $100,000 for you to try to evade tax requirements, right? And so 280E has criminal implications, and those criminal implications have, criminal justice implications just like any other criminal penalty. And so to say that rescheduling, has no criminal justice implications is just technically inaccurate. And it's also important to emphasize that as you deschedule, a lot of what's going on at the federal level and at the state level when it comes to the criminal side of enforcement, those are a lot of discretionary decisions that prosecutors and administrations make. And I think that that's a two-way street. So like right now, many of those entities are not exercising that discretion vigorously, right? We don't see them pouncing all over. Now, it's not to say that the criminal prohibition doesn't have an effect. It certainly does. However, as you move to less and less strict schedules along the rescheduling continuum, there's at least some notion that perhaps sentencing judges, prosecutors might take that into consideration when they're making the discretionary choices about whether to bring charges and how to sentence if charges are brought. And the last thing I'll say on this, which is another point that I think, is just kind of lost in the shuffle, is when you have a really dramatic change, like say a really revolutionary change, like descheduling, right? Now, I support personally descheduling vigorously, and I think it's the best outcome, and I hope we get there sooner rather than later. That said, one thing I would be concerned about, if you got descheduling, is that we get, sort of the pendulum or reactionary pouncing on that by, the enemies of cannabis reform, right? So you could imagine states that are prohibitionist states or an administration that opposes cannabis reform saying this descheduling is a bridge too far, and now we're going to tighten up all of these discretionary enforcement decisions that we normally haven't done, right? And the pendulum could swing back the other way. And that could be an unintended consequence. I'm not saying it would happen. I'm just saying that has happened in areas like immigration law when there have been changes of administration. And because so much is done at the state level, we need to think about how different it is more complicated than just to look at the black letter of what the schedules do and to ignore the political valence and the discretionary power that certain officers have when enforcing the law or not enforcing the law.
Yeah, I appreciate framing what is a legal or at least a practical possibility with the schedule change. I want to at least be able to respond and say, I assume that if judges are going to use discretion later, they could probably use that same discretion now. I agree and understand that there are criminal penalties associated with the tax code. I do want to, we can shift now into talking about the criminal penalties. We can come back to the banking issue, but let's spend some time talking about the criminal penalties, because I've seen folks on social media talking about some of the implications of rescheduling or descheduling cannabis, and some folks offering in part, Shane, what you offered, and that there could be some reduction in penalty if cannabis were rescheduled. But as I understand, there are cannabis-specific penalties. And so the reality is that it wouldn't matter if we rescheduled to 1 to 3 to 5, those cannabis-specific penalties would remain the same. And so I think we have to approach these conversations about kind of speculative possibilities about criminal justice reform with caution. I think we can talk about them as possibilities, but I wouldn't want to sell them as absolute, because I don't know that we can say that that's the case. John, can you talk a little bit more about how cannabis-related, marijuana-related penalties at the federal level could change if marijuana were rescheduled, descheduled, and then if you have any specific comments on our hypothetical of Schedule 3?
So in terms of the rescheduling of cannabis, it maintains all of the same criminal penalties that exist if you're purchasing from illicit avenues, or even, frankly, purchasing from state legal entities, which would remain illegal under federal law with cannabis rescheduled. It also, even if we get into a position where legislation happens, where Congress takes the step of removing cannabis from the Controlled Substances Act, it's still unclear what types of penalties the federal government would maintain for certain behaviors. So if you look at what states have done, no state has removed all criminal penalties for all activity related to cannabis. I mean, there are states that have legalized cannabis that you can still get a life sentence for trafficking large amounts of illegally grown cannabis in it. And so the federal government will likely also maintain some sort of criminal justice system or criminal justice process for large scale illicit trafficking of cannabis, I would guess. And so all that said, I'll also note the vast majority of interactions individuals have with the criminal justice system related to cannabis happen at the state level, the state and local levels. And so even the removal of simple possession as a federal crime is going to have such a minuscule impact on criminal justice in the United States. And removing cannabis from the federal schedules also does not strip a state of the ability to maintain cannabis as an illegal substance. And so it doesn't necessarily force the hand of Rob's home state, my former home state of Tennessee, from maintaining the criminal code with respect to cannabis. And so in a lot of ways, the process that we have seen, the progress we've seen in this country over the past 25 years, and particularly with regard to adult use cannabis over the past 11 years, that is the big step in terms of addressing criminal justice issues, because such a high percentage of arrests that end up becoming exempt happen at the state level. And the steps that governors and legislatures have taken and other institutions have taken to right those wrongs of the past and offer clemency to past offenders, that's the big criminal justice game changer in this country, not the Attorney General ultimately rescheduling or descheduling cannabis, or even necessarily Congress stepping in.
Thanks, John. Patty, I know that you spent some time earlier talking about penalties that could be applicable through the Food and Drug Cosmetic Act. Can you, just to tie these conversations together, can you articulate what those penalties are and whether or not rescheduling, descheduling would change those penalties, what those particular penalties, what activities those penalties are for?
Sure. So violations of the Federal Food, Drug, and Cosmetics Act can lead to federal criminal penalties, federal criminal prosecution. And in the past, FDA statute has been used to prosecute people who are distributing drugs for adult use that are not scheduled. But as I mentioned at the outset, FDA statute is really focused on the interstate distribution of products. So a product or its components has to cross state lines or cross, national boundaries at some point, generally for FDA to have jurisdiction. So it wouldn't criminalize mere possession or personal use, but there would be criminal penalties available potentially for. I think certainly for interstate distribution for medical uses, but the definition of a drug in FDA statute covers articles intended to treat, prevent, cure, mitigate disease, et cetera, or articles intended to affect the structure or function of the body. And it's that second piece of the drug definition that's broad enough to cover adult or recreational use. Again, as I already mentioned, and as Rob mentioned, right, depends on appetite for enforcement. FDA, like many agencies, does not have independent litigation authority. So all of its litigation, whether criminal or civil, goes through the Department of Justice. So it depends on also the Department of Justice's appetite for enforcement. But there are criminal penalties available under FDA statute.
Thanks, Patty. I want to shift back to talking just briefly about some of the industry impacts. And part of what I have represented here on this chart is marijuana industry banking. And I'll just note my thoughts, and folks can kind of correct me if I'm wrong. But my understanding is that rescheduling cannabis, moving it on the schedule is probably not going to won't have a legal impact on individuals' access to marijuana banking. And that's in part because the underlying commercial cannabis activity would still be considered illegal under federal law. As folks probably know, there is a bill in Congress, the Safe Banking Act, that would address this specifically by protecting financial institutions from federal enforcement for servicing the cannabis industry. And so if the Safe Banking Act passes, then banks wouldn't be subject to that potential enforcement. However, if cannabis were completely descheduled, then the Safe Banking Act itself would be moot. There would be no need for it. Does anyone else have any commentary on potential impacts to banking? All right. I'll shift. I want to be able to close out our conversation on the implications, talking about how the DEA and FDA authority could change if cannabis is either rescheduled or descheduled. So Shane, can you talk a little bit about what would change if cannabis was rescheduled or descheduled in terms of DEA authority?
So yeah, sure. So DEA shares authority with FDA over controlled substances. I mean, Patty's gone over the FDA's authority. FDA's authority doesn't change by and large. When a substance is descheduled, it's still subject to all of the interstate marketing constraints and the false advertising, labeling requirements, and so forth when marketed in interstate commerce, regardless of scheduling. So that wouldn't change. DEA's authority does change. So in order for DEA to have jurisdiction or authority over a substance under the Controlled Substances Act, that substance has to be on one of the schedules. And that means that the Attorney General has to have made the findings in 21 USC 812 relevant to placing it on one of those schedules. And so if it's descheduled, DEA doesn't have authority over it, much like hemp as an example, right? When the 2018 Farm Bill came out, FDA's authority remained. DEA was out of the ballgame with respect to hemp. Now, it's important to make one other point here, and that is that, if you're FDA, right, and you think about the amount of resources it would take to really strictly enforce the FDCA against the state level cannabis markets, and you think about the fact that FDA is a unique agency in the sense that a whole bunch of its money comes from pharma company user fees, and it doesn't have any, it's not like rescheduling would come with appropriations from Congress or something. So their budget would remain the same, and it would take a great outlay of resources in order for them to vigorously enforce the FDCA against cannabis. In general, I'm not that concerned about an FDA takeover if we were to see rescheduling. There's a slight difference there with descheduling, which again, that's the position I think is best. I just want to clarify that once you remove DEA from the equation with descheduling, that makes FDA the chief federal agency with authority over the substance, basically. I mean, others do too, like the IRS and others and whatever. But really, FDA would then, so if a senator wants to drag somebody in front of them to answer questions about this cannabis industry that they don't like, or whatever, they would go to DEA because it's a controlled substance. But if DEA were out of the mix because it was descheduled, that senator would be calling on someone from FDA to come, or HHS to come talk to them about that. And I think that is something that's probably maybe in the back of, to the extent that FDA really considering descheduling, I think that might be in the back of their mind. Do they want to be in the spotlight like that on this substance that maybe they don't have the appetite, or given no indication that they have the appetite to enforce against?
Yeah, I think that's helpful. It also kind of gets at this question that I think folks in like these criminal justice and social justice circles are talking about as we talk about marijuana reform. And it's like, are we going to treat this as a criminal justice issue or a public health issue? And I think, the agency in charge is largely going to dictate the approach that gets taken. But as you suggested, I think that there are different agencies that could be ultimately tasked with that responsibility. Ultimately, I think that this may be an area that we need Congress to have some proactive legislation on.
Yeah, could I just jump in quickly?
Yes.
One of the things I've beaten this horse a lot in my writing, and I know others on this panel have as well. One of the things that worries me the most about legalization, and I'm someone who supports federal legalization, is the lack of preparedness that the federal government has for that day to come. And I think one of the big takeaways for me from this panel is that we have parts of federal policy, I'll say policy, because there's law and there's regulation, in which the references to cannabis flow entirely through blanket statements about relationships to the Controlled Substances Act. There are other areas of policy in a variety of federal agencies that, as others have said on the call, have very specific cannabis-related rules. And so simply legalizing cannabis doesn't undo all of the knots that exist in a lot of federal agencies. And I think we often underappreciate how many different federal agencies touch cannabis in certain ways. And so I'll give you very briefly an example of something that happened in Maine a few weeks ago. So for those of you who are unaware, Customs and Border Protection in the US does not just exist at the borders and in airports. They have jurisdiction within 75 miles of international borders and navigable waters. And so they set up interior enforcement checkpoints. And so a licensee in Maine was delivering cannabis from his cultivation facility to retail stores in the state. And his vehicle entered a interior immigration checkpoint, and all of his product and cash were seized. And his product was destroyed by Customs and Border Protection. His cash is eventually supposedly going to be returned to him, but he was trafficking in a Schedule I substance. And so the federal officials stepped in. Now, my guess is, I don't know how the rules exist within Customs and Border Protection. I would bet that it is attached specifically to a Schedule I substance, but I'm not sure of that. And I think there's a lot of things that individually, there are a lot of experts who are very sure about the narrow specifics that they look at. But we really don't know what the implications or lack of implications are by federal legalization, whether it's through the administrative process or through a legislative process. And so I know a lot of people in the advocacy community sort of turn their noses up at the idea of a study committee of this, but a study committee is absolutely essential if we want any efficient, wide-scale, broad-based federal reform to happen, so we can look at all of these particulars, because cannabis has been institutionalized into federal policy for decades in ways that we just don't even fully understand at this point. And I think this panel, my colleagues on this panel have done a great job today of really highlighting just how intricate all of those things are in ways that we just don't fully understand.
Thanks, John. I agree. I mean, I think we do need to get better prepared for what's on the horizon, and there are all of these different implications. I don't disagree with this idea of a commission. My concern is that we talked about how the US had a commission before and how it disregarded the recommendation. If it had followed the recommendation of the original commission, we may not be in this place in the first place. And unfortunately, it seems as though our policies on cannabis in this country continue to be driven by politics rather than rational science or public policy priorities. That being said, I really appreciate folks' time and walking through the different issues that I consider a priority, but I do want to ask two more questions of each of the panelists. First, we can see on the screen, this is a statement that President Biden had put out actually before he took office, while he was running for president, articulating where he stood on marijuana laws. I'm curious, in your opinion, panelists, would rescheduling or descheduling or what would be necessary for President Biden to keep his promises as he's made them today or here on cannabis? Is he able to keep his promises on marijuana reform if we move to Schedule 3? And anyone?
I'll hazard, a solid no vote there. I think really that the key point I want to get across is that Biden can't do this himself. Most of these goals, if not all of them, would require congressional legislation. Yep. So to the extent that President Biden can work with Congress, try to strike some deal, try to get the ball moving there, he could fulfill these promises, but he can't do this unilaterally. That was certainly true. There were other presidential aspirants who overpromised to an even greater extent on the campaign trail. Bernie Sanders, Elizabeth Warren, for example, said, first day in office, first thing I'm going to do is totally legalize marijuana. And you just can't do that. We've talked about the constraints on the executive's authority, and those constraints are pretty potent. There's no unilateral way around them. So you got to work with Congress. That's the only way to get it done. And it's probably going to take something more than congressional legislation that says move marijuana to Schedule 3. But any way you accomplish that is going to require some congressional input.
Thanks, Rob. I think for the purpose of time, if folks could answer the question and then also respond with their one piece of advice for the Biden administration or Congress on federal marijuana reform. So Shane, you're in the hot seat.
Yeah, no problem. Legalize it. I mean, that's my advice. And that means working with the states, working with stakeholders. They need a broad push to get the information they need to regulate responsibly, which they do not have now. They should be talking to people like John Hudak and Robert Mikos about, and to all state regulators and to other stakeholders, people on the ground who know what's going on with this and getting the information. And they should be doing it post haste, and Congress should prioritize it because this is a mess that's we're not going to get out of simply or easily. It's going to take a lot of effort, and there's kind of a breakdown in how the information normally flows. Normally, the states are the laboratories of democracy, and we all benefit from seeing how those experiments play out. And the federal government gets the information from the states, and we go and we improve over time. But with cannabis, it's not like that, because the states are not, incentivized to communicate, and the federal government isn't listening. And we just continue to have this huge gap in state and federal policy, which undermines the rule of law. And it's just basically, un-American. And so, I hope that they do that. I hope they do it soon. It's important to understand that as historic as this process is, and as grateful as we should be for the incremental victories that we get, like everyone's been saying. I mean, it will not accomplish we are not going to fix all or even 20% of the problems here, no matter what the outcome is of this process, even if it were descheduling.
Thanks, Shane. Fatima?
Yeah, so unfortunately, much like Shane and Rob, my answer is that no, rescheduling does not get us to where Biden has promised he would get us. I agree that we definitely need comprehensive legislation, and the Biden administration should really work with Congress, work with states, work with state regulators in particular. You know, CANRA, all the cannabis regulators of America, they're already working with each other because they are anticipating federal legalization, right? And so there are state regulators that already have these sorts of plans in mind, but they need the federal government to step in and guide them as to what it is that the federal government is actually anticipating on doing. Because if they're just talking to themselves, but they're not talking to the federal government, there's a really big disconnect there. And so, you know, and we're going to start seeing, by the way, you know, in anticipation of eventual legalization, we're going to start seeing states enter into not formal, but semi-interstate compacts where they're going to start engaging in interstate commerce with each other on small levels to sort of test the waters and maybe even push the federal government to do something. And so it's really incumbent on the Biden administration and Congress to anticipate these situations happening and working with the states and working with stakeholders, small businesses, big businesses. You know, we already are seeing lobbying efforts by the tobacco and alcohol industries who know that this is coming and they want to be first in line. And so small businesses also need to be front and center in these conversations to make sure that all the businesses that are currently operating in state legal jurisdictions don't get completely decimated once federal legalization is here. So that would be my advice.
John?
Yeah, I agree with what everyone has said so far. What I'll add is that my advice for the Biden administration, and frankly, anyone who's interested in taking this issue on, is to just get better informed about it. One of the things that has shocked me is that presidential candidates, gubernatorial candidates, candidates for Congress are just so staggeringly ignorant about the realities of cannabis policy and how their ideas might actually get transformed into reforms. And it's true of the president, it was true of the previous president, it was true of the president before him, and all the rest before them. And so one of my worries when it comes to cannabis policy, and cannabis reform rather, and I touched on this earlier, is a lot of it's bumper sticker politics and policy. The reason we're in this mess is because cannabis was initially bumper sticker politics and policy. It's bad, it'll turn you into a murderer, it's corrupting our youth. Those are all really quaint bumper stickers. The solution to that is not more bumper stickers in the other direction. It's actually putting in the hard work of crafting policy, understanding how that policy gets executed, understanding the role of federalism in this process, and putting all of those ideas together into realistic legislation and realistic reform. A president's not going to be able to do all of the things that are on this list. A president's not going to be able to do the things, as Rob mentioned earlier, that Senator Sanders and others have said that they would do. It's a matter of just really understanding what cannabis policy is and how it needs to be changed.
Thanks, John. Patty?
Well, I know we only have 2 minutes left, so I'll just say I echo what everyone said, and particularly John's comments about how complicated everything is and how things are so interrelated. So I hope to see a more comprehensive approach than even if descheduling or rescheduling is a necessary part of that comprehensive approach, to see a comprehensive approach.
Thank you. For me personally, I think for the Drug Policy Alliance, the Cannabis Regulators of Color Coalition that I represent, we want to see full descheduling. We want to see that coupled with comprehensive legislation. For us, we think that both the president and Congress have both an opportunity and responsibility to push reform. I think that even if we land on a rescheduling decision, there's more that the president can do. I mentioned in part the publication and equity action plan for marijuana reform. And I think this gets at part of what everyone has mentioned here today, which is that there are many more steps. The Biden administration announced 3 steps. Well, we need 1,000 steps. And part of my priority as an advocate and reformer in the space is to ensure that the steps that we take are equity centered. And in order for us to do that, we have to have data. We have to be able to understand how cannabis policy is impacting stakeholders, how it's impacting issues. We know that those impacts today are immense. I really appreciate everyone's time, the panelists for volunteering their time and expertise. I know that we didn't get to many of the questions, but I will be working with the university to collect those questions, to put out responses. So thank you so much for your time. And I'll pass things back over to Holly.
Thank you, Kat. I think we're all set for today. Everyone registered for this event will receive a link to the recording when it is available, hopefully early next week. And thank you again for joining us.